Welcome to today's press conference. The Chief Executive will first speak before answering questions. Each media outlet may ask no more than 2 questions. Chief Executive, please. On the 28th of November, in accordance with Article 11 of the National Security Law, I submitted a report to the central authorities. In my report, I requested for the interpretation by the National People's Congress Standing Committee under Article 65 to clarify the legislative intent of the National Security Law on the question of whether foreign solicitors or barristers without general admission can participate in criminal cases of national security in any shape or form. The National People's Congress Standing Committee made an interpretation of Articles 14 and 47 of the National Security Law. I welcome the interpretation and I am grateful. The interpretation clarifies a number of points. First, under Article 14, the Hong Kong SAR Committee on National Security has the power to determine and decide on whether national security is involved. Its decision is legally enforceable. Institutions such as the executive, the legislature, or the judiciary, or any organizations in the Hong Kong SAR should respect and enforce its decision and should not interfere with the work of the Hong Kong SAR Committee. 2. The courts of the Hong Kong SAR shall obtain a certificate from the Chief Executive to certify whether an act involves national security or whether the relevant evidence involves state secrets when such questions arise in the adjudication of a case. The certificate shall be binding on the courts. 3. The question of whether overseas lawyers without general admission of the Hong Kong SAR can act for the defense or as an agent ad litem in criminal cases of national security is a question under Article 47 of the National Security Law. A certificate should be obtained from the Chief Executive. If the court has not requested for and obtained such a certificate from the Chief Executive, the Hong Kong SAR Committee should perform its duty under Article 14 of the National Security Law by making a determination or decision. The Hong Kong SAR Committee on National Security Law and the Hong Kong SAR government will fully perform their duty as stated in the interpretation. Such duty include first, determination and decisions to be made by the Hong Kong SAR Committee on National Security on the question of whether participation of overseas lawyers without general admissions or whether they can act as an agent ad litem in national security cases involves national security and policies to be adopted. The Hong Kong SAR Committee will perform its duty under Article 14. That includes 1. analyzing and assessing developments in relation to safeguarding national security in the Hong Kong SAR, making works plans and formulating policies for safeguarding national security in the region. 2. Advancing the development of the legal system and enforcement mechanisms of the region for safeguarding national security. And 3. Coordinating major work and significant operations for safeguarding national security in the region. 3. The Hong Kong SAR government will assess the risk and actively consider amending the legal practitioners' ordinance and to strengthen the institutional safeguard of the national security law. 4. The Hong Kong SAR government will perform its constitutional duty of Article 23 as well as Article 7 of the Basic Law to legislate laws that protect national security. We will also take into account the latest situation of the world and improve a local legal system so that we can resolve effectively problems we encounter and to effectively suppress and stop acts or activities that endanger national security. The National People's Congress Standing Committee acted in accordance with the power enshrined in the PRC Constitution and the Hong Kong National Security Law. It has clarified the legal meaning of relevant provisions and set down the duty of the Hong Kong SAR Committee. In relation to the further improvement of the legal system and enforcement mechanisms, as well as the effective safeguarding of our national security carried significance. The NPCSC is a standing organ of the highest level of the central authorities. Its interpretation has authority and binding effect. SAR courts, in accordance with the Basic Law, exercises independent judicial power and adjudication. Such a constitutional order has fully manifest the power of interpretation by the NPCSC and the power for final adjudication by SAR courts. The interpretation of the law has also fully clarified the compatibility of common law system as well as the one country, two systems. The highest principle of one country, two system is to safeguard national sovereignty, security, and development interest. The Hong Kong SAR will safeguard the sovereignty, security, and determination and the development interest. We will uphold the authority of the national security law. We will perform a duty and obligation of safeguarding national security to preserve one country, two systems. Now the floor is open. Please identify your media outlet and limit your number of questions to no more than 2. The one at the front in white.
Chief Executive, good evening. I'm from Ming Pao. In relation to Article 47 of the Basic Law, and that is the adjudication or the determination of whether an act involves national security. Who is to make that determination? The court, yourself, or the commission? And before is the determination subject to judicial review? Would there be worries that the committee can intervene with any criminal proceedings, for instance, whether a person can be set free and whether overseas judges can take part in the hearing of such cases. And you mentioned that the legal practitioners ordinance will be amended. Are you referring to overseas lawyers without general admission in Hong Kong, or will there be a vetting mechanism for overseas lawyers? Do you still welcome overseas lawyers to take part in civil as well as criminal cases in Hong Kong? Thank you. Under Article 47 of the National Security Law, it is clearly stated that on the certification, the certificate will be issued by the Chief Executive, and therefore the decision rests with the Chief Executive. However, in coming to the decision, the Chief Executive will take into account all relevant factors, in particular facts as understood and information as obtained by the Chief Executive in making a judgment as to whether an act involves national security or whether the relevant evidence involves state secrets. So it is the Chief Executive's decision, and the power to make that decision was already clearly set out in the national security law when it was promulgated. And therefore, this round of interpretation has not added to the power of the Chief Executive. As regards the Commission or the Committee for Safeguarding National Security, its power can be clearly seen in Article 14 of the National Security Law. Decisions by the committee, as set out in the interpretation, is legally binding. When the Committee for Safeguarding National Security makes a decision, of course, it will give due consideration to matters including the basic law, the national security law, and also local legislation. The decision of the committee must fully comply with legal principles. You mentioned the power of the committee to interpret the law. What you said was wrong. It doesn't have that power. The power to interpret the law rests with the National People's Congress Standing Committee. The interpretation was made under the basic law as well as the NSL. The committee has no power to interpret the NSL. We have to deal with this issue, and that is an overseas lawyer who is not qualified to practice generally in Hong Kong. We're referring to cases involving national security. So the scope is very limited. For most cases in Hong Kong, they are not related to national security because since the promulgation of the national security law, in terms of safeguarding national security, Hong Kong has been successful in safeguarding national security. We are now stable. Acts involving national security was seen in 2019. Acts and activities endangered national security in 2019. So cases in relation to national security only account for a very small portion of crime in Hong Kong. We are confident that with successful implementation of the national security law, cases involving national security will drop. We welcome overseas lawyers to practice in cases not related to national security because so long as they have obtained ad hoc admission or admission for a particular case, they can always participate in cases in Hong Kong. So we are only confining to cases related to national security. The interpretation has mentioned the certification of act that involves national security. The Committee for Safeguarding National Security has the duty to determine and decide whether a certain act involves national security. And once the decision or determination is made, it has to consider the merits of a case. So the details are not always the same. So whether we are talking about future amendment to the law, it will not impact on overseas lawyers participating in cases not related to national security once they've obtained admission for particular cases. So we are targeting a very narrow scope this round. We welcome overseas solicitors to practice in Hong Kong, overseas lawyers to practice in Hong Kong if they have obtained admission for particular cases from the court.
The one in the suit at the front. From CCTV. It's the 25th anniversary of reunification. There are 6 interpretations by the NPCSC covering many different areas, say, for example, the right of abode and the term of the chief executive. Well, it has become an important part of our system. Do you think that the NPCSC can clarify the legislative intent of the national security law for its full implementation here? With the promulgation of the national security law, we can see that acts that undermine national security law is under control. Law and order has been restored to our society. Members of the public can carry on with their normal lives. So when it comes to how we've done with the implementation of the national security law, we have done what we have expected us to do. But in the implementation of the national security law, we encounter new issues. And there may be different views in relation to the interpretation of the national security law. The significance of the interpretation by the NPCSC well, the NPCSC is the highest organ of our constitutional order. It has authority and it has the final decision. There is no need and no room for further argument and debate. And as you can see, that the interpretation on this occasion is of a specified scope and issue. It tackled a particular principle. The interpretation is not about a particular case. The interpretation has clarified the duty of the Hong Kong SAR. We're talking about the executive, the legislature, as well as the judiciary are now very clear about their duties of the implementation of the national security law. The interpretation this time has also clarified the duty and functions of the Hong Kong SAR Committee on Safeguarding National Security Law. That's why I said that I have read out the functions and duties of the committee. That includes development of a legal system and enforcement mechanism. When we encounter new issues or questions, the interpretation has paved a clear path for us to follow. This path will ensure that we will be able to fully implement the legislative intent of the national security law. And this is conducive to the performance of our duties and obligations. That's why I said that it carried significance. And the interpretation is also a manifest of the power of interpretation by the NPCSC, as well as the independent judicial power and adjudication of the Hong Kong SAR courts. That itself shows very clearly the principles involved. The one in black.
Some English questions from the South China Morning Post. Firstly, under the interpretation by the National People Congress Standing Committee, the matter of allowing overseas lawyers without the full right to practice in Hong Kong to defend clients involved in national security cases will rest either on the Committee for Safeguarding National Security or on yourself as a chief executive. We want to ask, would Jimmy Lai now be able to apply to employ an overseas lawyer for his case through the courts if he wishes, and what would the relevant procedures be in that case? And also, by allowing the chief executive to have the power to determine whether overseas lawyers are allowed in either the Committee for Safeguarding National Security or via himself through approving a certificate, is this unfair to any potential defendants due to a conflict of interest? And what is and secondly, you also talked about how the government will raise an amendment to the legal practitioners ordinance. Can we ask what do you mean by this amendment, and also whether or not there would be a timetable on when these amendments would be made? And also, what is your stance on hiring overseas lawyers for national security cases, and why welcome certain overseas lawyers for other types of cases, but not those involving national security? Thank you.
That is a very long, serious question, which actually has broken the tradition of answering two questions. But anyway, I'll try to answer them as fully as possible. Well, first of all, we have to pay attention what actually the interpretation covers on this occasion. It covers 3 points. First of all, it touches on the duty of the Hong Kong SAR National Security Committee's duty and functions. And it also talks about how Article 14 and Article 47 can be used to do the certification of an activity, whether the activity relates to national security or whether the information concerned relates to national secret. So it is an interpretation to allow us to understand more how the national security law actually means in these areas. So in regard to your first questions about Jimmy Lai's case, the interpretation, first of all, doesn't deal with a particular case. The interpretation deals with principles. The principle of how Article 14 and Article 47 should be applied so as to help Hong Kong solving the problem it faces. In fact, it is a principle that should be applied to solve other problems that may arise in the Hong Kong SAR implementation of the Hong Kong national security law. So it is principle, it is not case that the interpretation deals with. So it will be up to Hong Kong to make use of Article 14 and Article 47 to deal with the case concerned. What it means is, in respect of this case, we are dealing with the issue, I mean the Hong Kong SAR, is dealing with the issue whether an overseas lawyer who hasn't got full practicing rights or qualifications in Hong Kong should be allowed to take part in any national security cases. So it will be up to Hong Kong SAR itself to deal with that issue. That means the Hong Kong National Security Committee will have to examine the issues and then make a judgment and make a decision as to how this matter will be addressed. The second thing is the Hong Kong SAR itself, particularly the government, has the responsibility to fulfill its obligation to protect national security. So Hong Kong SAR government can and should also exercise its duty to look at how and what we can do to address the question whether an overseas lawyer or barrister who hasn't gone full practicing rights in Hong Kong, whether he should be allowed to take part in a national security case, taking into consideration all the risks that may be involved. And then the Hong Kong government should examine the way to deal with it. And equally, the Hong Kong National Security Committee may address a particular issue, making use of the power under Article 14 and Article 47 to address the question. And then after the National Security Committee has made a judgment and decision, then, of course, the Hong Kong SAR government will examine how to implement it. The power of the chief executive to issue a certificate to certify whether an activity relates to national security or any information relates to national secret is a power that has been given to the chief executive since the enactment and the implementation of the Hong Kong national security law. So it has been there on the very first day when the law was enacted and implemented. The chief executive's duty is to look at all the information available to him to make an assessment and then certify whether a particular activity relates to national security or any information relates to national secret. This is to deal with certification. And in any trial, the judge is to examine the evidence and the facts of the case to make his judgment independently. So the certification is a fact that he will take into consideration, but whether a person is to be found guilty or acquitted will be based on the evidence and the facts that are presented in the court for the judge to make his independent judgment, free of interference. The third thing is regarding the examination of legal practitioner ordinance to see whether there is a need to amend it. Of course, the Hong Kong SAR government, in fulfilling its obligation to protect national security, have to weigh on the risks whether such participation by an overseas lawyer or barrister without full practicing rights, looking at the potential risks, and then see whether we should amend the legal practitioner ordinance. When there is a decision to amend it, and of course, then it will be through a bill presented to LegCo for it to be considered in accordance with LegCo procedure. But I must emphasize, what I'm talking about and what the issue in front of us is a very small area, i.e., looking at an overseas lawyer or barrister without full practicing rights or qualifications, whether they should be allowed to take part in national security cases. Beyond national security cases, then they are most welcome, provided they satisfied the procedure to obtain an ad hoc admission approval by the court. As regard timetable, we will very quickly look at all the risks, as I have mentioned, and if the decision is made that we should proceed with the amendment, then of course we'll do it ASAP. Your last question is about overseas lawyers or barristers practicing in cases other than national security cases, then I have already answered it. They are most welcome, and there has been the practice before, provided they satisfied all the requirements and procedure and obtained the High Court's ad hoc admission approval.
好，時間嘅關係，我哋答多兩條。
In the interest of time, we will take only 2 more questions. The lady in black. Good evening, I'm from Tsingtao. Now, Articles 14 and 47 are involved in the interpretation. 47 involves a certificate from the Chief Executive, and Article 40 involves the Committee for Safeguarding National Security, of which the Chief Executive is the chair. So you have powers under both articles. So are you worried that information available to you may not be entirely accurate, leading to mistakes in your decision? And will you request the NPSC to give you directions? And there are worries that this interpretation may cause people to query whether judicial independence has been undermined. Do you think there will be repercussions among the legal sector? First, Article 47 of the National Security Law states that the Chief Executive has the right to issue a certificate. That power was already there from day one when the law was promulgated. It is not something new coming from the interpretation. Article 14 is about the Committee for Safeguarding National Security. It has got different members, including 3 secretaries of departments, the Secretary for Security, and also 3 secretaries of departments, and also national security representative appointed by the Central People's Government. While the committee is chaired by the Chief Executive, decisions by the committee is a collective decision of the committee. It is not the CE's personal decision. So decision coming from the committee belongs to the whole committee. Of course, as the chair of the committee, the Chief Executive convenes and chairs meetings and will preside over the deliberations of the committee. But let me stress that the committee is a committee, and any decision by the committee is a decision of the whole committee. In coming to any decision, the committee will give full consideration of information available to the committee and also the actual circumstances before making a decision. Secondly, when we handle matters related to national security, now we have to safeguard national security. The Central People's Government has confidence in the SL government, and through the national security law, we are empowered to handle cases related to national security. And hence, under the delegation, the SL government will act in accordance with legal principles and evidence available to us in coming to decisions. Furthermore, this round of interpretation, as I said, fully manifests our legal principles. We have fully manifested the respective duties and functions of different organizations in the SAR. It is a manifestation of the spirit of law. The Standing Committee of the NPC exercise its power to interpret the law under the Constitution and the national security law, and our courts acts in accordance with the national security law and exercises its power of adjudication and final adjudication under the basic law. This fully reflects our mechanism and our legal spirit and spirit of the law in implementing the national security law, governing the country in accordance with the law. And the SL also acts in accordance with the law. This spirit of the law and the rule of law has a positive impact over our legal system and enforcement. The interpretation has boosted people's understanding locally and internationally, and how prudent we are in implementing the national security law. We attach importance to the rule of law, and we defend the interests of defendants. They have the right to a fair hearing, and then they enjoy all sorts of rights and freedoms in accordance with the law. And the scope of interpretation is very limited and focused. We are talking about the principle and not individual cases. So in implementation of the national security law, we attach significance to the spirit of the law. So this is a positive move. I believe the legal sector will give full recognition to the fact that in implementing any law, we respect the rule of law and we act in accordance with the law.
Questions from the last reporter.
Sorry, Mr. Lee. 2 questions from AFP. First of all, according to the interpretation, the matter of overseas lawyers representing defendants in national security cases is just one of an unspecified category of national security matters that may up to you and the National Security Committee's assessment. So even you said that the national security cases is just a very small area is it that in that area, the National Security Committee has become a court above all courts in Hong Kong, and you, as the chairman of the community, as the chairman of the committee, has become a judge above all judges? Second question. You said that in non-national security cases, overseas lawyers are still most welcome to practice in Hong Kong. However, we all know that national security cases in Hong Kong do not only cover NSL crimes, it may also cover sedition, for example. So can you once and for all tell all the overseas lawyers what are non-national security cases in Hong Kong? Or, in an opposite way, what are national security cases in Hong Kong? Thank you.
Can you first of all repeat your first question, because you've asked quite a few.
Of course. My first question is, under the interpretation, the matter of overseas lawyers representing defendants in national security cases is just one of an unspecified category of national security matters that you and National Security Committee may assess and decide. So, even you said that national security cases form a very small area, would it be that at least in that area, the National Security Committee has become a court above all courts, and you, as the chairman, has become a judge above all judges?
Okay. Well, first of all, your premise, I have to correct it. The interpretation on this occasion clearly explains the purposes and intention of the Hong Kong national security law by specifying the role of the chief executive in assessing and certifying whether any activity relates to national security and whether any information relates to national secret. And of course, you will know that for a lot of activities, they can vary in the actual execution of what is intended to be done to harm national security. So there will be a variety of actions that may endanger national security, which a country face, whether it is our own country or any other country. Espionage, for example, can take various forms. So it is the duty of the chief executive to certify whether any activity actually relates to national security. So it is this certification which is Article 47 is specifying. This power exists in the Hong Kong national security law since its enactment and implementation. So the interpretation of Article 47 does not create extra power for the chief executive in such certification. The chief executive only does the certification. He is not to rule on a case. All cases are ruled by judges in court in accordance with the law and the evidence and facts in front of the judge. And each case, the defendant is fully represented by lawyers chosen by him who will be arguing the case on his behalf. So the chief executive doesn't play judge at all. So it is a wrong premise, and it's a wrong interpretation. And since the chief executive is not a judge, so there's no truth in your description of anything to do with above the judges, because the certification only aims at certifying a particular activity relates to national security. And the Hong Kong national security law stipulates only 4 offense types. But for activities that endanger national security can be beyond the 4 offense types of the Hong Kong national security law. That is why I have always been telling people that the Hong Kong national security law is a law which addresses only some specific activities which endanger national security. In fact, there are a lot other activities that may endanger national security which are not covered by the Hong Kong national security law. They may be covered in other Hong Kong laws, such as the Crimes Ordinance on treason. The Hong Kong national security law doesn't cover treason, but the Crimes Ordinance of Hong Kong does. So you are right, there are activities which may endanger national security, which goes beyond the coverage of Hong Kong national security law. That is exactly why the Hong Kong SL government has a duty to enact law to satisfy Article 23 of the Basic Law, and also to improve the system and the legal coverage for activities that may endanger national security. But this will be done through local legislation. And this is the duty of all government of any country to safeguard the country's national security through successful implementation of the laws. Because safeguarding national security is a state's responsibility. And it is the responsibility, I think, of almost all the states around the world. And the Central People's Government has trusted the Hong Kong SL government to implement laws to safeguard national security. And we have to do it to fulfill our obligation, because under the Hong Kong national security law and also under the Basic Law, we have this constitutional duty. Thank you very much.
記者會結束，多謝大家。
That's the end of the press conference. Thank you.